We got a quorum. Do we have a quorum? Yeah.
It's never printed a minute, but she took the bill. Did she need to print that? If we were gonna read the language, because this is just inserting.
Yeah, we do. That was 1092.
Yes.
Okay, so you want to skip it till we can get the date. Okay. Okay, I'll call the meeting to order. We have a quorum. First bill I'll call up is House Bill number 845 for charitable organizations require an IRS form filed annually with the Secretary of State to be for the most recent fiscal year end. This is the same bill that we passed, our Senate Bill 2272. It requires charitable organizations use their most recent year-end financial report in reporting to the Secretary of State as required by law. There's been some confusion as to which financial report an organization should use. This just clarifies that it's the most recent they have for ending their financial year that they gave to the IRS. This clears up the language so as to make sure that it's clear to them and clear to everyone else. If there are questions, I'll be glad to answer. If not, I'll take a motion. No questions? Title sufficient, do pass is the motion. All those in favor say aye. Opposed, no. Motion carries. Thank you. Next is House Bill 1021. Pawnbrokers authorize Commissioner of Banking to establish by rule a process allowing certain purchased and/or pledged goods to be stored off premise from the place of business. I'm going to ask Senator McMahon to explain.
This is the House version of the Senate bill we already passed, which would allow pawnbrokers to store products or pledge products off-site in a secure location. There's two sections to the bill. Section 1, line 39, the commissioner may establish by rule, regulation, or order a process to allow certain purchased goods to be stored off premises at a secure non-residential location. And then the section 2, that's dealing with a different code section. The commissioner may establish by rule, regulation, or order a process to allow certain pledged goods to be stored off premises at a secure location, non-residential location. So, like I said, it's the version we already passed. Now yield for any questions.
Any questions from the committee? Motion.
Title sufficient, do pass.
Motion is title sufficient, do pass. All those in favor say aye.
Aye.
Opposed, no. Thank you. Let's have it. We're going to skip House Bill number 1092. We have the amendment that we're going to ask that we put in the bill, but we did not have a printout of the bill. So that should be able to happen before we conclude here today. So we're going to skip number 3 on the list, which is House Bill number 1092, and move to House Bill 1105, where a limited liability company will remove prohibition on using the words partnership and limited partnership when providing a name for that corporation. This bill removes 2 names from the restricted list that was used in the naming of an LLC. Those 2 names are partnership and limited partnership. It does this on line 26, where in the original law, these 2 terms were specifically excluded by striking them from the language. So this just allows LLCs to use the term partnership and limited partnership in their name if they so wish. Any questions? If not, do I have a motion?
Title sufficient, do pass.
Motion is title sufficient, do pass. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Thank you. Next, we'll move to House Bill 1344, where nonprofits will require an annual report to be filed with the Secretary of State. It is a strike all, so please pay attention to that. But currently, organizations are expected to file a status report with the Secretary of State's office. This legislation requires that an annual report be filed by the nonprofit, and that includes foreign nonprofits. On line 100, you see that there will be no filing fee for the nonprofit. There will be no fee to file the annual report. On line 32, it specifically says that any nonprofit that received public funds has to declare that. On line 50 in section 1, which is the whole new section, we are excluding water associations, nonprofit water associations, from having to file this report because by law, they already are filing a report with the state auditor that should cover the same information. Then on line, let's see, 100, public, that's really the gist of the bill is, in section 1, you'll see what information is going to be required by the Secretary of State for this report. If there are no questions, I'll take a motion. Any questions? Motion? Yes. Senator Owen.
You, Mr. Chairman. So when the Secretary of State requires an annual filing of an annual report or I guess it's a reauthorization of an LLC, for example. And it's due, I think, April 15th, if I'm not mistaken, but you have a grace period of 6 months, October 15th, to file before you suffer a dissolution. Does this bill do the same thing for nonprofits?
And I don't think that's correct. Allison would have to look at that.
LLCs have to file by March 15th, annual report.
Right, but this is not LLCs. These are nonprofits.
My question is, are we going to accord the same extension to a nonprofit that we accord to LLCs, for example?
That is not in the bill.
Thank you.
Any other questions? Motion?
Not sufficient to pass, strike all.
Title sufficient to pass, strike all is the motion. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. Thank you. Okay, next we'll go to House Bill 1408, which is also a strike all. This is a residential roofing contractors revise the requirements under Insurance Benefits Roofing Repair Consumer Protection Act. I'm going to ask Senator Branning if she will to present this bill.
Mr. Chairman, the purpose in this bill is really for consumer protection as it relates to roof repair, and particularly we see issues after a storm. And we have some really good contractors in our state. There are many, many of them doing an excellent job, and they do things the way they should. But as we all know, sometimes when we have disasters like that, we see folks come out that don't always do things the right way. So this is an attempt to curb some of the abuse as it relates to insurance, the insurance claim process on roof repair. And so some of the items that you'll see in the strike all, currently there is a 3-day cancellation period in roofing contracts. This extends that or increases that to 5 days. It also protects consumers from having to make a payment prior to that 5-day cancellation period. Any excess payments won't have to be made until that period expires. And then it prohibits a roofer from representing or negotiating an insurance claim. We feel like that the contractor, the roofer ought to be involved in the process at some point, but we're just defining, when and how that ought to take place. Prohibits a roofer from contracting, agreeing, or receiving anything of value from referring a claim to an attorney. You'll see that that's in section 3E1. And then it protects consumers by limiting the practice of the post-loss assignment or the assignment of benefits, as I think we more commonly understand that process, to allowing the roofer or the residential contractor to being named as the co-payee. So it limits that process. And what happens when there is a disaster, what we have seen is that some of these individuals, these contractors travel around and convince some homeowners to go ahead and assign their benefits over. And so we see in that process, that's where some of the abuses take place. And the claims process, the repairs that are needed, some of that may be inflated. And at the end of the day, the person that suffers are the homeowners, the people that are having to pay the insurance premiums, because we do find an increase in those premiums that result. So those are the things in the strike all, as I understand it. There's also a reverse repealer. We're continuing to talk to the home builders, as I understand it and appreciate it, as well as the insurance folks, to make sure that we have all the details right and that we understand what we're doing with the bill. So with that, Mr. Chairman, I would entertain questions. Title sufficient to pass, strike all. Thank you, Mr. Chairman. This bill comes to us by request of the farm credit agencies in our state. And I know that many of you are familiar with how those farm credit agencies operate. They're member owned, and their members receive dividends over a certain specified period of time, some annually, some biannually. And under our current law, when these members fail to cash those dividend checks timely, then it becomes property of the state. Now, current law indicates that a period of 5 years has to pass before, it elapses to the state. But there are other similar associations in our state that they're frankly exempted from this part of our law, things like the rural water associations, some utility providers and others. And so what this bill does, it puts the farm credit agencies in the same exemption category, so that when there are dividend checks that aren't cashed over time, instead of becoming part of the unclaimed property fund of our state, it goes back to the farm credit agencies, which again is a member-owned agency. And under this bill, those funds would have to be used in a manner to benefit all of the members. And so I understand it's a very small amount of money. You're talking $3,000 to $4,000 per year per farm credit agency, and I believe we have 3 of those in our state. So that is an explanation of the bill. Happy to yield for questions.
Questions of the committee members to Senator Branning? If not, Senator Branning,
Title sufficient to pass.
motion is title sufficient to pass. All those in favor say aye. Opposed, no. Ayes have it. Thank you, Senator Branning. Next, we'll go back up to Senate Bill 1092 that we skipped. You now have a copy of the bill and an amendment that we expect to present to you. This is the automobile airbags and supplemental restraint systems, establish standards for installation. And I've asked that Senator Suber present the bill to the committee.
Thank you, Mr. Chairman. Apparently, I've lived a very sheltered life, and I didn't realize we had such a problem with airbags. But here we are today. We're having a problem with a lot of fraudulent airbags being installed in vehicles. And basically, this law is just gonna, if it goes into law, it's just gonna allow our federal and state law enforcement agencies to crack down on the issue we're having. In Section 1 is basically just defining an airbag, supplemental restraint systems, non-functioning airbags. And in Section 2 and 3, we're taking federal definitions and codifying it into statute. Basically, if we have someone who is ordering, installing, anything that's not would be a functioning airbag, that could be a crime and could be a misdemeanor, which is up to $5,000 fine and 1 year in prison. And I do have an amendment at the proper time, but I'll be happy to answer any questions right now. All right, and the amendment be added after line 83. And this was requested on behalf of the automobile dealers. This will prevent some liability to the automobile dealers if they unknowingly sell a vehicle that has been installed with an improper airbag. And the problem with these airbags is they're not functioning. You know, I was reading some of the notes we had that they're installing newspaper or just nothing at all in the airbags, and so they're not properly protecting people if they were an accident. So that's why this law is needed at this time. But I'd move to adopt the amendment as part of the bill.
I understand that it protects them for liability and what does it exactly do?
So if they sell a vehicle, I'm assuming a used vehicle, this ain't gonna apply to new vehicles, I wouldn't imagine, but if they sell a used vehicle that someone had already had altered with an airbag, that they wouldn't be liable if they didn't have any knowledge of the effective airbag being installed. Thank you, Mr. Chairman.
So I'm assuming this is just on like vehicles that have been repaired and airbags replaced. Surely we don't have issue with manufacturers installing
That's correct.
faulty,
This is
okay.
manufactured. That's why I don't think it would apply to new vehicles. This would be strictly to used vehicles.
Other questions? All right, so we have a motion that we accept the amendment. All those in favor say aye. Opposed, no. The amendment is accepted. Now we're back on the bill with the amendment. Any questions on the bill itself with the amendment? Okay. There are no questions, Senator Suber? Not sufficient to pass as amended. All those in favor say aye. Opposed, no. Motion carries. We probably will have a meeting tomorrow. Just be aware and be looking for that. But right now we have one is not scheduled. Do I have another motion? Rise and report. That's always a good one. Thank you.